Today I'm discussing a rule of evidence called adoptive admission. What is an adoptive admission? We all know what an admission is. You admit something like when you admit that you are guilty of a crime. An adoptive admission is different. It is actually an admission by silence. Ever find yourself in a situation where someone says something about you and your silence seems to speak louder than words? In the legal world, this concept of an adoptive admission can carry significant weight, potentially even suggesting guilt in a criminal trial. So let's start with a definition. What is an adoptive admission? An adoptive admission occurs when a person does not deny a statement made outside of court that accuses them of a crime or connects them to its commission. This silence can be interpreted as an admission of the statement's truth under specific conditions. Let's break down what this means, because it's not as simple as silence equals guilt. The court has a very specific set of hoops to jump through before a jury can consider your lack of denial as an admission of truth. Imagine this scenario. Someone loudly accuses you of being involved in a crime, and you stand there, not saying a word. Can the prosecution later argue that your silence means you're guilty? Not necessarily. Here's why. The court will only allow the jury to consider your silence as an admission if all of the following conditions are met. 1, you were there and heard it. The statement accusing you or connecting you to the crime must have been made directly to you or in your presence. If it was whispered across the room or happened when you weren't around, it doesn't count. You understood what was said. It's not enough just to be present. You had to actually hear and comprehend the accusation. If the speaker was speaking in a language you didn't understand, or if the circumstances made it difficult to hear, this condition wasn't met. 3, a normal person in your situation would have denied it if it wasn't true. This is a crucial element. The court will consider all of the circumstances surrounding the statement. Were you in shock? Were you advised by a lawyer to remain silent? Was the situation hostile or confusing? If a reasonable person in your shoes wouldn't have naturally spoken up to deny the accusation, then your silence can't be held against you. 4, you could have denied it but chose not to. This implies that you had the physical and mental capacity to respond. All right? If you were physically restrained, unconscious, or otherwise unable to speak, then your lack of denial doesn't count. However, if law enforcement is involved, then the adoptive admission rule may not apply. The rule does not apply if the defendant's silence stems from invoking their right to remain silent, as this is protected under cases like Griffin v. California. The bottom line is this. If all 4 of these conditions are met, the jury may conclude that by not denying the statement, you essentially admitted it was true. However, if even one of these requirements isn't satisfied, the court will instruct the jury to completely disregard both the statement and your reaction. It's as if it never happened.
Daniel Horowitz is one of the nation's most highly experienced trial lawyers. You can reach Daniel at 925-283-1863. Thank you for watching our video.